Let me start again. Assalamu alaikum. Good afternoon, everybody. I should like to thank the SCCA for organising such a wonderful conference and for kindly inviting me to participate in it. My presentation today is going to look at damages in construction arbitrations. I started my career as an engineer and as a quantity surveyor working on construction projects. And I used to see how badly the lawyers dealt with quantum claims. So I thought, let me become a lawyer. Perhaps I can do better. So I became a lawyer, and through 30 years of practice, I still see around me quantum claims being done very badly. So let's see if we can look at ways in which things can be done better so that in the construction context, the employer, the owner of the project, pays no more than he is required to do so, and the contractor recovers no more than he is entitled to do. Let's first of all remind ourselves. Let's remind ourselves about construction projects. They have a bunch of characteristics. Typically, they are high-value projects. They are technically complex. They often involve many parties. Generally, the contract interfaces between those contracts are often not as well prepared as they perhaps could be. And sometimes the contracts contain different legal provisions providing for different choice of law, different forums for dispute resolution. These matters, when they come together, give rise to what are commonly known as a trinity of issues, where one or more of the three issues of time, cost, and quality can adversely impact a construction project. Let's look at each of those very briefly. Time. Well, there's issues about when the project is meant to finish. Does it finish on time? And as many people in this room will know, there are often penalties or damages imposed should a project not complete as it should. So there will be delay damages or liquidated damages. Sometimes those liquidated damages will relate to the quality of the works as well. Where the work finishes later than it should, there'll be extra costs incurred because the contractor has to maintain all of his site, his people, his plant, his utilities, and also the people in his head office longer on the project than he might have planned to do so, and that causes him a loss. The contractor may have also been suffered disruption. He's worked less efficiently than he had planned to do so because he hasn't been able to start at A and go all the way through to Z in one go. He's been required to stop, go elsewhere, come back, because perhaps permits hadn't been obtained or access to the whole site wasn't available. So all of these things can conspire to prolong the time. Also, as the project goes on longer, there are additional costs incurred by way of escalation or inflation. There also may be issues as to how you manage what's called concurrency, where there are more than one issue causing these events and who should be responsible for it. And then there's cost. If you have disruptive working, it's going to cost you more. You're less efficient. If the scope of the contract changes, it's going to cause you to incur expense. There may be variations where the employer wants something different, and that's entirely right, but in doing so, there may be a dispute about the actual cost of doing that something different. And then, of course, there is always the arguments about how much money a party is entitled to, both by way of interim valuations, so progress payments or milestone payments, or indeed the final valuation, how much money is to be paid at the end of the day. And of course, additional things get in the way. There may be a change in the tax law of the country. There may be additional costs incurred by way of government charges. There may indeed be additional costs incurred with matters such as performance bonds, that we've heard Aisha talk about. But if performance bonds have been wrongly called, then a party will be subject to costs from its bank, as it has to finance the money that's been paid out by the bank to the other party. With apologies to my French colleagues in the room, but there's also quality issues. There are defects, latent and patent defects. Latent defects are ones which are not readily apparent at the time, but come to be recognised at a later stage. There'll be issues to do with value engineering, disputes about whether the project is being done in accordance with the specification or whether you can improve the specification by utilising a different product or a different way of working. All of these matters can conspire together to create a complex interaction of issues. You won't be able to see, I'm sure at the back, a lot of the detail on this chart, but it just seems to show some of the interaction of issues. So, for example, the resources which are being applied over a period of time, and those resources may become delayed in their application because of early delays to the project. They may be extended over a period of time, so you end up using more resources. At any particular time, you may need more men and plant on a project. All of these have a cost component. The project may need to be accelerated, sped up, and again, that requires more people, more plant, and therefore may generate more cost. To recover damages, to recover the additional costs, there needs to be a legal or contractual entitlement. Often it arises out of a breach of contract. Many construction contracts have mechanisms for dealing with the assessment and the payment of additional costs. Parties don't always respect those provisions. They sometimes breach them, and therefore with those breaches of contract, a liability to pay damages may arise. And damages are compensatory. They're intended to not cause a losing party to profit, but just return parties back to the position they should have been in. But there needs to be causation. There needs to be a linking between the contractual entitlement and the loss that's been incurred. There are questions about how the claim is presented. It's very common in this part of the world to present a claim as a global claim. That is, for a party to argue that my construction project was going to cost me $2 billion to build. For these reasons, it's now cost me $3 billion, and therefore I claim the additional cost, the additional $1 billion. However, that approach doesn't necessarily take into account the fact that the claiming party may be responsible for some of that additional cost. So therefore, the other approach, which is generally preferred, is a bottom-up basis, which is where the individual claims are valued and proven and then paid. But the key point is, without decent records, and as a famous English judge once said, to succeed in a construction claim, you need three things: records, and I'll leave it to you to work out the third one. When you have the records, you have the evidence that you need in order to prove your claim. And by working with good quality experts, you can then take that evidence and present it in the strongest possible way in conjunction with your legal team. And talking about experts, we've heard already during the course of this conference something about experts, but it's really fundamental to be successful in your claim, to be clear as to the role that experts are to play and how to use them effectively. In arbitration, it's becoming more and more common, for very good reason, to require the experts not just simply to produce experts' reports, which can, frankly, be like ships passing in the night, but require the experts to work with a joint brief, so both experts are working on the same instruction. They all should be required by the tribunal to meet with each other to agree a common approach. If they can't agree a common approach, then they should address the other person's approach as well. So the tribunal has both cases before itself and can decide which one it prefers. So by having joint statements, the issues between the experts can be narrowed, and therefore the tribunal can be much more effective than it would be otherwise. However, regard must be had to the law and the policies against recovery, and most legal systems, including KSA, have restrictions on what may be recovered. One has to take into account limitations and exclusions. Most contracts, especially construction contracts, have many limitations and many caps on liability throughout them. They need to be studied carefully. Often the law, both in civil law and common law jurisdictions, has rules against uncertainty. In our Guerre, because uncertainty leads to injustice. Because if there's lack of certainty, then no one knows whether they really are paying for what is being claimed. And therefore, there are various tests which have evolved in different legal systems. So under English law, there's a test of remoteness. Is a damage that is being claimed, is it too distant from the actual event which took place? Likewise, there's issues about consequential loss. In many legal systems in this part of the world, consequential loss is not recoverable, or if it is, there are severe constraints upon it. And that's, again, for good reason, because often consequential loss may be too remote, may be too uncertain, and therefore it's not fair to require a party to pay something when it cannot be proven that that loss has actually been incurred. So there are a whole bunch of other matters which need to be considered in your particular jurisdiction, and whether you can claim or whether you are liable to make payments for matters such as loss of profit, interest, moral damages, and whether there's a penal or punitive aspect to it. There are also some quite specific issues relating to construction damages, issues such as concurrency, which I touched upon briefly already. For example, if there is a delay and the contractor is claiming that he's been delayed by the employer, but he may have also caused his own delays, is it right that the employer should be required to pay the prolongation costs as a result of those delays? There's also issues about the costs which are actually claimable. We've talked about site costs, but what about the head office costs? Companies maintain their head office staff. These people work on a variety of projects at any one time, but indeed they still incur a cost if they stay on a project longer than anticipated. And indeed, in that context, various formulae have been developed in order to try and assess the way that costs, head office costs, can be determined. Formulas such as the Hudson or the Emden or the ICLAY formula. All of these, to some extent, are a bit mumbo-jumbo because they work upon calculations of the contract price against changes in the contract value, etc. And they don't necessarily prove the actual loss that's been incurred. And therefore, tribunals will generally want to see that there has been a true loss, that by a project overrunning, there has been a loss of opportunity to the contractor. So when a contractor is claiming for his head office costs, he needs to also demonstrate that actually he wasn't able to secure any other work at this time because of this overrunning project. However, if he wasn't able to win the work because the market was poor, why should he recover those costs? Because those people would never have been employed in any event. Let me just finish with some top tips for dealing with damages claims in construction arbitration. I've mentioned records. These are critical. So many times parties leave money behind on the table, so to speak, in arbitration because they cannot prove a claim either for a claim or against it because they don't have the records. It's vitally important that parties administer their contracts properly, have the right people engaged to maintain records so that claims can be either progressed or rebutted according to which side you're on. Contractual notices, absolutely critical. If you don't comply with the notice requirements of the contract, most legal systems will serve to exclude the claim and stop you from pursuing it. Often claims are not particularized in the way they should. They have to be persuasive. When you go before an arbitration, a tribunal is looking to be persuaded. If it doesn't understand the claim or isn't persuaded that the claim is genuine because there isn't the necessary particulars to explain it, not only is it unfair upon the other side, it's also just going to fail in front of a tribunal because a tribunal will not award something it does not understand. So it's important to particularize things carefully. Causation is critical. I've spoken about the linkage between the contractual entitlement and the loss incurred. That has to be proven. I've spoken about the experts. Experts should be able to agree. They should be able to agree at least numbers as numbers. So they may not agree with the principles that each party is claiming, but when they are studying the evidence and looking at the records, they should be able to agree that this record confirms this value. But at the end of the day, a tribunal is dealing with credibility. It is assessing the credibility of the parties, the credibility of the claim. If it is well presented, well particularized, the witnesses and the evidence stack up, then that claim will have credibility and stand a better chance of succeeding than if it does not. So credibility is critical. And as a closing point and as a plea as an arbitrator, assist the arbitrator to find the right answer. Ensure the evidence is persuasive, clear, concise, and helpful. Thank you very much.